Sound familiar? Yeah.
Honestly, didn't even want to rap on this.
Used to run through the money, now I'm too old. Man, I'm just playing. Shot when I land. Promoter paid for 6 flights. Got the team right. I just told Mr. Band. Came in for the bands. Beachside Villa for aesthetic. Just because and I don't even like the sand. Stan Smith sneakers on the beach. That's the water. I just came in for the tan. This was always planned. You wouldn't understand. I could turn a Chevy to a Cullinan. I could turn a Rolls to an AP. I came from sorry sir to come again. I came from 2 screens to HD. Tell her why you mad for. Go on, tell her why you mad for. No new friends, I couldn't catch a win until I cut off the loose ends. Used to whip the under in the trunk at 210s. Just like that too. Out the speakers was max speed. Couldn't say a thing about the way if you asked me. Never caught the chain, I was always trying to gain green. Riding around with my sexy love in the passenger seat. Tell her why you mad for. Go on, tell her why you mad for. Go ahead and just give me a reason not to change on you once I give me a million. I got checks in Hamburg, I might fly out this evening. I got checks in Moscow, I'll be back in a weekend. If it wasn't for COVID, I'd be in Europe touring. Counting cash on the couch is getting kinda boring. Must be talking about kids when you talk driving foreigns. Say I'm lying and I'm telling stories, or you can't. Tell her why you mad for. Don't tell her why you mad for. Silly. Soft spoken, I can hit the studio and spit till my jaw's broken. For records in the hour, I'm not bragging, it's all boasting. Pen the top 10 and ball for ball, and it's all coasting. And it's easy for me, just tell me go on, I'm on go, it's no reason for me. Doing features for a feature that's reaching for me. My next show's a mattress store, they been sleeping on me. See, they took my style, see, they been peeking on me. That's why I'm mad for.
They try to say like, ooh, that's a cute song, that's a cute song. But let me bar for bar real quick, just to wake you up, get you out your sleeves. It's like, you know what I mean? Like,
I know what you mean.
Yeah, a little reminder. Set a reminder on your phone. Wake up at 6 a.m. like me. Go to sleep at 12 like me. And it's still sleep gang.
Right.
You gotta get your rest, stupid.
What up, though? This your boy Tay Biz, man. What's going on with everybody today? I'm excited today, man. I gotta admit, I'm excited today. I hope everybody had a great day. It's been a long day. It's been a tiring day, but it's a good day, man. Any day above ground is a good day. Look, I'm just super excited right now, man. I was working today, and I was at work, and I was checking my phone and everything, and got an email from YouTube. And they were saying that I hit over 500 subs. So I appreciate hitting over 500 subs today. We just celebrated over 100 a few days ago. And now I'm over 500. And I appreciate everybody supporting. I appreciate everybody subscribing to the channel, liking the videos and sharing the videos. And I mean, the Woody Speaks video just blasted off, man. There's over 50,000 views on it right now. So I just appreciate everybody once again, man. If you are watching, man, come on and hit the chat up, man. Hit the like button. Let's go ahead and get this thing popping. You know what I'm saying? Appreciate the mod coming through. Hey, Tay, yes, congrats. I appreciate it so much. Thank you all so much for your love, for your support. I definitely appreciate it. We went live the other day, and it was a good live, very, very good live. And so I really enjoyed that with everybody. And so we just gonna keep it coming, keep it going, keep working, keep pushing. You know what I'm saying? But today we got some stuff going on. Brian still went nuts in his motion, man. When he went completely berserk. Julie, what up, Doe? In the building, Julie, what up, Doe? I appreciate you. We hit over 500. We over 500, man. So let's do this. All right. So I know the time is a little bit late. I know the West Coast, y'all 3 hours behind. No, but it's 7:20 here. You know what I'm saying? So we're gonna go ahead and get the show popping, get it moving. Hit like this live real quick. That's how we get into the algorithm. That's how we get everything popping, get everything going. So before we get going with the actual motions and all the documents that's been filed, because Brian still went bananas. I ain't gonna lie, he went bananas. And also included in this particular motion is the email. All right, it's the email in there too. Look, Julie says 4:20 in California. Yep. You got plenty of time. You got plenty of day. The rest of your day is good. You still got more of your day ahead of you. You know what I'm saying? So, but we are here, man, to talk about something real quick. But before we do, I want to say shout out to my man, My Take TV. I want to say I appreciate you. Send me something. And man, it had something to do with DA Love in the courtroom one day, and she was hand signaling a witness on the stand. And we're going to dissect this a little bit. All right, we're going to go ahead and share this real quick. See if everybody can see this. Matter of fact, let me drop myself down here like that. So I want y'all to check this out, right? Because this is interesting, because this is not the only time that I've seen people talk about the corruption so much at a different level. You know what I'm saying? Like the fact that she's hand signaling a witness is insane. Let's check this out real quick. Let me see what you recognize on this.
Brought Mr. Matthews, and I believe Miss Westmoreland, but her grounds were not determinable. But anyways, I'll sustain the objection.
So that's Love and Hilton right here. Now watch DA Love. Watch DA Love. Okay, you see that move? She's sitting up already. Look, she already sitting up. She changed her demeanor off rip. Look at that. The details, man. It's in the details. Check this out. Look at the man dead in his face. Dead in his face. Wow, man. Let's go.
One in particular, Mr. Heffinger, because that's the one that I had all my attention drawn towards from what the victim was telling me.
Hold on, man. Hold on. Check this out now. Let me full screen it real quick. That's even better. Okay, now we can look at this. Check this out. Look at her hand signals on this.
Mr. Heffinger, because that's the one that I had all my attention drawn towards from what the victim was telling me. As far as who took the vehicle. Like, yeah, she said there were other people in the vehicles, in the second vehicle, but like I said, we're more concerned about trying to get the actual person inside of.
Now, let's be clear about something, because we got to go back to this real quick. All right, let's be clear about something. All right, so as an attorney, and if you're calling for a witness as an attorney, it is your job to prep your witness to go on the stand. It's your job to do that. Look at Julie. Look. Wow, I saw her signal the judge before, but not with it. Exactly. She's signaling. She's telling the witness to, okay, what we discussed, go ahead. Go. You cannot do that. You cannot do that, Miss Love. She knows this. She knows that you cannot do this. This is absolutely insane. Check this out again.
One in particular, Mr. Heffinger, because that's the one that I had my attention drawn towards.
Right there. That's nasty work. That is nasty work. Okay, yes. Attorneys are supposed to prep their witness, prepare them. Attorneys are supposed to let the witness know, like, okay, this is direction. These are the questions that I'm going to ask you. And these are some of the questions that you're going to get in cross. You're supposed to prepare your witness for, what to expect. All right. She is telling him, she's insinuating. And remember, in this area, next to my man right here in this area is the jury. They're right next to her. Now, a lot of people have talked about the fact that Miss Love has all these gestures and hand signals, and she does all these facial expressions, and the jury is right, not too far left from this guy right here. Check this out one more time. Check out her demeanor. She's talking to Miss Hilton right here. Check out her demeanor when it's time for the attorney to ask this man questions. What my take? I appreciate you, but I just showed you love. Shout out to my take once again, man. Shout out to you, my boy. I appreciate you, man. I told you we was gonna do this. Listen, this is Hilton and Love talking, and watch this. Watch her demeanor change. There it is. Bam, right there. Right there.
One in particular, Mr. Evans.
And my man, she looking dead at him. Dead at him.
Because that's the one that I had on my attention.
It is right there. Boom, boom, boom.
What the victim was telling me.
That's crazy work.
As far as who took the vehicle. Like, yeah, she said there were other people in the vehicles, in a second vehicle. But
you could tell the witness is trying not to look at her.
Mr. Evans, that's the one that I had all my attention drawn toward.
You trying to look away?
As far as who took the vehicle.
This is terrible,
she said
man.
there were other people in the vehicles, in a second vehicle. But like I said, we're more concerned about trying to get the actual person inside the Toyota.
The head nod too. The head nod too. Listen, trust me, we are starting off with this. Listen, we slow rolling today. All right, we're gonna take our time today. We're gonna take our time tonight. All right, we're gonna take our time tonight. We taking our time with this. Okay, I got a nice piece for us today. All right.
Like I said, we're more concerned about trying to get the actual person inside the Toyota.
Yeah, now right there.
And were you also looking for another car besides the vehicle?
There was a 10 in color car.
Look at the cameraman is smart on this one. It's too late, cameraman. It's too late, cameraman. It's too late. It's too late, cameraman. We already caught you. We already caught her. Let's go back. Watch the demeanor. Watch the body language. Sitting up, bam, right there. So that right there is an intimidating tactic. That demeanor is okay. You know what we talked about. You better say it. You better say it the way we talked about this. You better say it the way I'm telling you to say it now. Where we talked about this. All right.
One in particular.
Try not to look at it.
Because that's the one that I had all my attention drawn toward from what the victim was telling me.
Here come the head nod.
Who took the vehicle? Like, yeah, she said there were other people in the vehicles, in a second vehicle.
Here it comes.
But like I said, we're more concerned about trying to get the actual person inside the Toyota.
Right.
And were you also looking for another car besides the vehicle?
Her looking at him again.
Color car.
Look at his eyes. Look at his eyes. You see his eyes. He looked at her. He looked at her. Look at his eyes. Right there. Right there. Who you think he looking at? Who you think that witness looking at right there? Who do you think that witness is looking at right there? He is looking dead at Miss Love. You know, the Miss Love that, coincidentally, unfortunately, had a immediate medical emergency with a family member. Just the day of her response for the brief was supposed to be turned in. However, that's neither here nor there. He is looking dead at this woman, eye to eye. Miss Love is intimidating her own witness. This is what they do. This is not nothing new. They intimidate their own witness. This is what it is. Who you think he's looking at? He's looking at Miss Love.
One in particular, Mr. Heppinger, because that's the one that I had on my attention.
Come on now. Yeah.
The victim was telling me.
You cannot do that in front of no damn jury. I'm sorry. I wasn't even trying to cuss today. You are not. There is no way you're supposed to do this in front of a jury. Boo Boo said, "Free thug, my brother." Absolute. He's an officer. He's an officer on top of that, bro. Oh no. Oh no, bro. Oh no, bro. Oh no, bro. That's crazy. And he's an officer. Look at this.
As far as who took the vehicle, like, yeah, she said there were other people in the vehicles, in the second vehicle, but I just said we're more concerned about trying to get the actual person inside the truck, Toyota.
And were you also looking for another car besides the vehicle?
This is crazy.
There was a 10 in color car.
That's right there.
About that one, man.
Jesus.
Do you know any more about Mr. Counsel?
No.
That's perfect.
Anything further, Mr. Adams?
Look, all right, now watch this though. Shout out to my man, My Take TV for this. I appreciate you, bro. Appreciate you, bro. All right, so speaking of signals, I want y'all to check this out, man. This is Attorney Hilton and the Judge Glanville. Check this out. What was that? What was that? What was that? Y'all might want to see that again. Yeah, let's see that again. Yo, man, what is going on in Fulton County, man? What is going on, man? Look at how Glanville. Look at how Glanville. I'm gonna play it again. Just a case. Look at how Glanville. He's making eye contact with the deputy and Hilton the whole time. The whole entire time he's looking at. And as soon as she lift her head up, he give her one of these. Your ear don't itch. Your ear don't itch, bro. Your ear don't itch. Chantry said, definitely suspect. Like, why the hell y'all making signals that he wanted to? Like, seriously, you're in court. Look at this. Old military tactics. That man was a part of the military. That's right. Look at this. One more time. Look at this. Unbelievable, man. Unbelievable, man. Shout out to my band, My Take TV, man. I appreciate you, bro. This is the thing that we have to understand about what's going on. It's like, why is a lot of people talking about this case, especially in the way it's going right now? You got to remember a few things about this case. First of all, we need to remember that there are 3 new people on the witness stand. Attorney Love, Attorney Hilton, and Judge Glanville himself. Judge Glanville himself. The man is going to be a witness in his own courtroom. In his own courtroom. Now, what I wanted to do was go ahead and read these motions here, because is very, very important. I wanted to do, again, I was going to make a video and I was going to just, upload a video for it. But shout out to everybody for again, over 500 shows, man. And we growing, man. And we growing. Little fish, big pond, right? But let's go. Let's get into this real quick. All right. So here is the actual motion. All right. If y'all can see this. Let me know if y'all can see this real good. Or I could drop myself down. Yeah, I dropped myself down. That's better. Y'all can see it better that way. All right. So we're going to read some of this. This is 233 pages. I'm not going to read all of it. Don't worry. Don't you worry. I'm not going to read all of this because we have some other documents that we need to read as well from Judge Krause from today. All right. So this right here is the state of Georgia. Again, this is state of Georgia versus Jeffrey Williams, supplement to motion to recuse Judge Glanville. And look at these. These are footnotes. Let me go ahead and these are footnotes. Let's go right to the footnotes. All right. We know what this part is. This is the preliminaries. We know what that is. The footnotes right here. Hold on. It says here that this motion applies to lawyers Love and Hilton, and in addition to Judge Glanville, as all three are material witnesses in the case at bar, and all will be called by Mr. Williams during trial to show judicial and prosecutorial misconduct. He's about to call them out on their bullshit. He's about to call them out on their bullshit. He said they are all material witnesses. What does that mean? That means they were there. They were in the chambers. They were there. They were at the scene of the crime. All right. Says this motion also timely moves to recuse the Honorable Judge Krause based upon the fact that she sits on the Fulton County Superior Court bench with Judge Glanville, and that in April 2024, Judge Glanville contributed $2,000 to the Honorable Judge Krause's reelection campaign. Oh my God. Oh my God. Oh my God. What? Wait a minute. Judge Glanville gave her $2,000. Now, to break this down a little bit, contributions between lawyers and judges and all that kind of stuff, that's not uncommon. There's actually a transparency board, and it should be in every state, I believe, but I know the state of Georgia has it, where it's okay to have a limit to what you can actually donate. Okay. So I think the actual donation limit went up an extra $800. So now I think it's like $8,400 that you can, donate to a fellow public servant, if you will. However, most of the time, judges and lawyers and stuff, they don't donate that much. They donate like $500 here and there and stuff like that. But he donated $2,000. Let's continue. Also in April 2024, the Honorable Judge Krause donated $500 to Judge Glanville's reelection campaign. Now, I must correct something. This is actually false. Okay. See, this is a supplement to motion. It doesn't mean everything it's not an affidavit. Okay. An affidavit is written facts. This is a supplement to motion. So a supplemental motion may not have, it has more allegations in there as well. However, they're not, but there are mixed with facts as well. This actually is not true. Judge Krause has never donated to Judge Glanville's reelection campaign ever. Okay. So I just want to be fair in that. So, but the fact that he gave her $2,000 is actually a lot of money, according to people who donate like that. Mr. Williams' trial has been going on since January the 4th, 2023, and therefore includes April 2024. Wow. So that means that Glanville was donating to Krause during this trial, and now that Glanville has a recusal upon him, and the judge is Krause, Brian's still saying that might be it might be some bias going on right here in this particular instance. It may be some bias right here. So that's why Brian Steele is bringing it to the attention of the court. And then they have cited some cases here. Undersigned counsel derives no happiness when filing this supplemental motion. However, let justice be done though the heavens fall. Actually, the heavens will not fall by unmasking bias and unethical members of the bar. Oh my God. Oh my goodness. Hey, Brian still said he coming for your ass, boy. Brian still don't like Glanville, dog. I'm gonna tell you how. I'm gonna tell you how, okay? Hey, I'm gonna tell you how Glanville don't. I'm gonna blow it up a little bit more. Glanville, you see the Honorable Judge Krause, Judge Glanville. You see that? I'm telling you, the devil's in the bloody details, people. The Honorable Judge Krause, based upon the fact that she sits on the Fulton County Superior Court bench with Judge Glanville, Judge Slimeville, Landfield, huh? He's not the Honorable Chief Judge. Brian's still petty, man. Brian still is petty. See, I also write as well on my spare time, and I mean, I've written a lot of different literature materials. Let me tell you something. This is petty at a high level of petty. That's a fact. This is a fact. He don't respect them anymore. Shout out to all my mods in the building, though, man. Y'all representing today. Shout out to all my mods. He don't respect them anymore at all. At all. You could tell that. Undersigned counsel, they say they derive no happiness to do this, but man, the heavens will not fall by unmasking bias and unethical members of the bar. Jeez, oh Pete. Says the Honorable Supreme Court of Georgia has taught that a motion to recuse is timely filed under USCR 25 if it is filed within 5 days after the affiant first learned of the alleged grounds for disqualification, excluding Saturdays and Sundays. So he's like, I did this on time. Thus, this supplement to motion to recuse is timely filed as the additional reasons for this recusal we first learned on Monday, July 1st, 2024. So technically, it's a week, 5 days. When Judge Glanville permitted the court reporter to release to undersigned counsel the transcript of the Monday, June 10th, 2024 ex parte, the infamous ex parte meeting between Judge Glanville, lawyers Hilton and Love, the Honorable Attorney Bumps. Look at this guy, man. This guy is petty, dog. This guy is petty, man. He don't put honorable at all. He don't get no respect. You mean to tell me he respect Caleb Bumpus more than Judge Glanville? He the chief judge. He said, I don't give a damn. I don't care. I don't care. And her client, sworn witness, Mr. Kenneth Copeland, Lil Woody, and others. We're going to get to these exhibits in a minute. Said this timely file supplement to motion to recuse has also been timely presented to the Honorable Judge Krause and Judge Glanville Petty again, bro, on Monday, July 8th. All right. It says here in this case, in the case at bar, Judge Glanville's ex parte communications with a sworn witness, his counsel, lawyers Love, and Hilton and other representatives with the Fulton County District Attorney's Office are seemingly only partially captured by the court reporter. Ooh, Judge Glanville Lawyer Love and Lawyer Hilton have prejudiced and tainted Mr. Williams' trial so deeply as Judge Glanville has not acted as a judge, but morphed into an essential part of the prosecution team. Not morphed, dog. Ooh. He has morphed into a prosecutor. He's like, yo, he's bought. He's sold. He's bought and sold. He's not honorable Judge Glanville anymore. Ex parte communications are presumed to be harmful error, and any conviction and sentence will be reversed unless the state proves that the error was harmless. Cited another case. Mr. Williams timely raised his objections to these ex parte communications and recusal of Judge Glanville, to wit, when he first learned of saying. All right. Wait, hold on. Sacrosanct. He put the sacrosanct means most sacred or holy, inviolable, immune from criticism. So he's trying. Oh, remember that? When Judge Glanville was like, you are doing this against the sacrosanct sanctness of the court and all this kind of stuff. What's so holy and sacrosanct about your chair? Man, let's go. All right. Canon 2, Rule 2.9 of the Georgia Code of Judicial Conduct forbids a judge from considering ex parte communications as judges shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. Judge Glanville embraced his view that the communications at the ex parte hearing were privileged. That was privileged information, Mr. Steele. How did you get that? How did you get this? That was ex parte. Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside of the presence of the parties, of their lawyers, concerning a pending or impending proceeding, except communications for administrative purposes, emergencies, consultations with experts or court personnel, and settlement conferences. So basically, he is just pretty much citing Rule 2.9, which basically says that these are the criteria of having an ex parte communication. If you are doing anything outside of this, then it is considered to be a violation. All right. It is also clear that ex parte communications are presumed to have been in error. And once a party has shown that a judge has received an ex parte communication, there is presumption of harm that can be overcome only by an affirmative showing that the judge did not consider this communication. He cited some more cases. In the case at bar, there is not a scintilla of evidence to overcome the presumption that these impermissible, illegal, and unethical ex parte communications, as captured in attached Exhibit B, resulted in harm. Thus, Mr. Williams' case should be reversed on direct appeal if there is any conviction and sentence. Letters sent to judge by witness was not harmful error, where the party asserting the error did not argue that the judge responded in any manner or gave the letter any consideration. As shown in the joint affidavit attached hereto as Exhibit A, Judge Glanville not only conducted this improper and unethical ex parte meeting, Judge Glanville therein acted as an advocate, for the Fulton County District Attorney's Office as he dispensed legal advice. Yes, he did, and supported lawyers Hilton's and Love's goal to have Mr. Copeland testify against Mr. Williams and the other co-indictees. Dang, that's true. If you all read the transcript, he does tell Woody, well, if you do this or do that, you won't get caught, or you want this, or we can't prosecute you. We can't do this. You cannot do that. You're the referee, bro. You're the referee. You're not supposed to get involved in a fight. Have anybody ever seen a boxing match? What is the referee there for? It's to make sure that there's a fair fight. It's to make sure that to protect the interests of both fighters, to make sure that if one fighter got the advantage over the other and he's beating them to a bloody pulp, then I need to make an executive decision to stop that fight. So that way the other person won't hurt himself further. You're a referee, man. You're not supposed to get in the fight and help the other person. Tell them how this other fighter you can take advantage of them by giving them advice like that. You see what I'm saying? He is acting as an arm of the prosecution. Absolutely. Absolutely, man. It says here, in light of this ex parte proceeding, it is impossible to conclude that Judge Glenn, he is not calling him honorable not one time. This is crazy. Judge Glanville is impartial and not a member of the prosecution team. Judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, including cases in which the judge has a personal bias or prejudice concerning a party or a party's lawyer, or personal knowledge of disputed evidentiary facts concerning the proceedings. Code of Judicial Conduct Rule 2.11. Judge Glanville has been derelict, in his judicial duties and must be recused. Once evidence of this illegal ex parte Star Chamber meeting was revealed by undersigned counsel in the afternoon of June 10th, in open court, lawyers Hilton and Love sat mute while Judge Glanville found undersigned counsel in contempt of court and sentenced undersigned counsel to the longest possible time in jail for unmasking Judge Glanville's, lawyer Love's, and lawyer Hilton's improper, illegal, and unethical conduct. Judge Glanville must be recused from any further action on Mr. Williams. Okay, now look here. Let's talk about that for a minute. Remember that point right there. Remember that time where he was being held in contempt, right? They did not say anything. What did they say, though? They did say something. What did they say? When they saw Brian Steele leave the courtroom to go in that box in the back, what happened? They said, Your Honor, we want to, the attorney Love, Your Honor, we want to find a different way of, going about this situation because, Mr. Williams do have the right to counsel. Because Attorney Adams said, hey, man, I can't do this on my own. I'm not the lead attorney. You know what I'm saying? So I can't do this on my own. So Attorney Love, so why did she speak up like that? She spoke up like that because it's an automatic mistrial if you take away a defendant's right to counsel. That's why he like, yo, you could go ahead and do your jail time on the weekends, and in the middle of the week, you can go ahead and come to court. That's why he did it that way. This guy is absolutely insane, man. What's wrong with Glanville, bro? What is wrong with Glanville, man? He's compromised, dude. The reference section of the Georgia Code of Judicial Conduct are meant to be self-enforcing. So that's sua sponte. And it is the judge's duty to disqualify himself as soon as he is aware that the grounds exist. So remember in the trial, how many of y'all, if y'all been actually watching the actual trial itself, put a one in the chat. If you've been watching the trial like on Law and Crime or whatever you've been watching it on, because in the trial, the lawyers were asking for a certificate of immediate review. So once he denied the motion of recusal, then he also denied the certificate of immediate review, which means like everything is supposed to stop when they have a legitimate concern. Everything is supposed to stop, and then you're supposed to go through all the things you need to go through in order to make sure that this particular matter at hand is worth being recused of. And you're supposed to do that on your own. You're supposed to voluntarily do that on your own because remember, your courtroom is so sacrosanct so sacrosanct courtroom, inviolable, right? That that you're supposed to be able to uphold the integrity of the law. He said, Glanville, you didn't do none of that. In the case at hand, the state cannot show that Judge Glanville's, lawyer Love's, and or lawyer Hilton's intentional and willful complicity in these ex parte communications was harmless error, as shown in Exhibit B. The improper influence and interjections by Judge, not honorable, dishonorable Judge Glanville and his two cohorts, from the Fulton County District Attorney's Office on Mr. Copeland, changed Mr. Copeland's stance not to testify against Mr. Williams. Gee, two cohorts, two bosom buddies. They was in cahoots. Gee, man. I mean, we still is not. He is saying some stuff in here that's like, you don't never see this from a lawyer to a judge like this. He hasn't one time called him honorable, like at all. This is actually, can you imagine Judge Glanville on the stand in his own courtroom being questioned by the guy who wrote this? I don't know about you all, man, but I ain't gonna lie. I cannot wait to see that. Oh, I cannot wait to see that. I hope I got the day off. I hope it happens when I have a day off, too, so I can just stream it. If Mr. Copeland refused to testify, all of his prior false inculpatory statements as to Mr. Williams would not come into evidence based upon Mr. Williams' constitutional right to confrontation. So all these, if Mr. Copeland had refused to testify, all of his prior false inculpatory statements as to Mr. Williams, that means things that are not true, untrue, no evidence of untrue stuff, then wouldn't even be in evidence. Intimidation tactics were thrust upon Mr. Copeland by the combined work of Judge Glanville, lawyer Love, and Hilton, resulted in Mr. Copeland's decision to testify, and thus Mr. Williams has another witness to challenge at trial. He stated some more cases here. Moreover, ex parte communications are so disfavored and repugnant that even if the ex parte communication would be cumulative of other evidence introduced at trial, same would not be harmless error because the ex parte communications are presumed to be reversible error. Mr. Williams' fundamental constitutional rights were trampled, ignored, and violated as a result of Judge Glanville's, lawyer Love's, and Hilton's improper, unethical ex parte meeting with witness Copeland. Moreover, the cover-up, secrecy, not sacrosanct, no, secrecy and silence of these three team members is unforgivable. To wit, after the Star Chamber meeting, the three public officials, quote unquote, simply strolled into the courtroom, faced the cameras, called for the jury, and feigned to continue trial as if nothing out of the ordinary occurred just hours and minutes before. You mean it? What is Brian still saying? These motherfuckers walked in here. They done had a whole secret meeting, right? They done walked in the courtroom like nothing happened. I mean, let me ask you a question. Have you ever knew something about someone that they did to you, and you know already what they did, and when they come around you, they act like everything, they act like they have done absolutely nothing, and they talking to you, what up, dog? Hey, girl, they're doing the whole nine, right? And then you like, wait a minute, you stole some money from me. Let's use that for example. I know you stole some money from me. I have evidence that you stole money from me. And you walk in like you ain't steal nothing at all. Wow. Now, these are supposed to be fellow members of the bar. They walk in there like, It's just ex parte. Ain't no big deal. Yo, that's insane, man. He said they strolled in. They strolled into the courtroom, man. They faced the camera. They was like, "What up, though?" You know what I'm saying? What up, though? Dang. Mr. Williams needs to examine Judge Glanville, Hilton, and Love, and all other members of their prosecution team to reveal the date and time of every ex parte communication that occurred concerning Mr. Williams' case since its inception. Whoa. What is he saying? What is he saying? He's saying, listen, I don't believe this is the first one ever happened. This is just the first one that we caught you in. But there's some more ex parte meetings that occurred, and we want to know what they are. Since its inception, the subject of saying and order the court reporter to produce any transcript of same and or unsealed all documents from these potential improper ex parte communication. Yo, he's like, we know it's more to this. Undersigned counsel needs to cross-examine all parties to ensure that the sworn testimony is spread in open court on the record. Dang. Mr. Williams' trial is constitutionally broken based upon the unconscionable, I'm sorry, I'm over here messing up words. You know what that is? Misconduct of Judge Glanville. In other words, he has no conscience about it at all. No conscience about it. He doesn't even have, he's seared in his mind. He doesn't even care. He's unconscious when it comes to the misconduct. He don't have no feel for it at all. Neither does Love or Hilton. They're all working together in effort to convict Mr. Williams. The criminal justice system in Fulton County, in the state of Georgia, and in America has been attacked by the conduct of these three actors. Whoa. He called these three actors. Steele is gone, y'all. He gone. Brian Steele is gone, man. Listen, Brian Steele is out of there. Like, he's checked out. He's checked out. He just called Glanville, and he just called Love and Hilton actors. This injustice must end immediately, beginning with Judge Glanville removed and disqualified from Mr. Williams' case. Thereafter, this motion is also timely made for Lawyer Love and Lawyer Hilton to be removed and disqualified from the trial. And Fulton County District Attorney's Office must be investigated for their improper conduct, if any, outside of the actions of Lawyer Love and Lawyer Hilton. Jeez, Pete. Judges must scrupulously, avoid improper ex parte communications, whether or not they consider them. A judge has the ethical duty to recuse himself sua sponte anytime the judge is aware of grounds to do so. What does that mean again? That means he must recuse himself on his own, based on his own integrity. Judge Glanville did the opposite of recusing himself sua sponte, even though he is keenly aware that helping Lawyer Love and Hilton to influence Copeland to change his mind and testify against Mr. Williams is not permitted by any judge in any court. Instead, Judge Glanville, the chief judge in the Superior Court of Fulton County, Georgia, has taken upon himself, at the behest and encouragement of Love and Hilton, to ally himself with prosecutors in this case. Judge Glanville's misconduct shall not stand. The law must be followed. Judge Glanville must be recused and disqualified from Mr. Williams' case instanter. That means immediately. Oh, this is crazy. I'm actually reading this with you all. I'm being honest with you. Like I read a lot of this, but I didn't even get this far. Yeah, he don't care anymore. He still does not care at all. He is out of there. He's out there. For everybody that's coming in, we are reviewing the supplemental motion that Brian Steele placed against Judge Glanville. And I believe Judge Krause had to review that. It was 223 pages. We're gonna get to the good stuff in a minute too. And I also have the document of Judge Krause's denial as well. This is absolutely crazy. Let's see here. Let's move on here. All right. So if this honorable court disagrees, wait, no, hold on. No hearing is actually needed to reach the finding that recusal of Judge Glanville and Stanter is mandated. Like we don't like this is just for formality. We don't even need this. We don't even need this. All right. Judge Glanville has automatically caused his recusal and disqualification from Young Thug's case by unlawfully becoming actively involved when he presented argument refuting affiant's allegations of judicial bias. If this honorable court disagrees, Mr. Williams respectfully requests a hearing, as he will call Judge Glanville, Love, and Hilton as witnesses. Woo-hoo. Witnesses to fully unmask this above discussed misconduct, as well as further misconduct that may have occurred. He said, look, if y'all disagree, we can have a hearing of just us three. Now we can have a different type of ex parte meeting. Now we can have a different type of ex parte meeting. Okay, since y'all want to talk in secret, how about y'all do it with us? We could all talk and fully unmask the misconduct. This judicial and prosecutorial misconduct denotes a disgraceful episode in Fulton County courts, the district attorney's office, and stains courts throughout the state of Georgia and our country. What occurred in this star chamber, outside of the view of the cameras, in the shadows and hidden from Mr. Williams and his counsel and the public, is unpardonable and all in violation of Mr. Williams' constitutional rights stated herein, as well as in Exhibit A. Judge Glanville, Lawyer Love, and Lawyer Hilton have created secret star chambers proceedings, which the state of Georgia has promised its citizens it would never engage. Wow. Judge Glanville, Lawyer Love, and Hilton have teamed up to conduct their illegal and unethical conduct outside of the view of Mr. Williams and his counsel, the public, and outside of the lens of the cameras. These public officials, my man is gone. My man is gone. He got the air quotes popping. He gone, man. He out of there. These public officials shall never be trusted by Mr. Williams or underside counsel. There are serious consequences for these intentional and unjustified misdeeds that have not yet been dispensed. The clear evidence is that Judge Glanville is not impartial, and or there is at least the appearance that Judge Glanville is not impartial. Judge Glanville must be removed, disqualified instanter from Young Thug's case. As sworn to in Exhibit A, Judge Glanville, Love, and Hilton conspired to conceal and suppress Brady evidence. This star chamber cannot prohibit Brady evidence from coming forward. Them evidence to free my client. Y'all talking in a secret meeting, and there's evidence that is potentially, excuse me, I can barely start tonight, Brady material that can free my client, man. This is absolutely crazy. And you prohibited it from coming forward. That is exactly what Glanville, Love, and Hilton planned to do. In other words, my client is being targeted. My client is being targeted. Listen, let me tell you something. Hold on, y'all. Hold on. Do y'all want to see an interview that Brian Steele had concerning Young Thug and what's been going on with him? Hold on, let me see if I can pull this up. I told you we're gonna be doing a little cooking tonight, y'all. We're gonna be doing a little bit of cooking tonight, y'all. There is an interview that Brian Steele did talking about Young Thug in the case. And man, let me see if I can find this. Let me see if I can find this. Yep. Here we go. Yeah, boy, it's on it. Okay. Y'all want to see it? Put a one in the chat if y'all want to see this. This is Brian Steele. This is Brian Steele talking about his client, Young Thug. This is I think this particular interview was, let's see here. It was over a year or so ago. Well over a year or so ago. Oh yeah, we about to get into this. Okay, this is about a 13-minute video, but check this out with your boy. All right. Hold on. Here we go. In fact, I'll do it this way. Brian Steele being interviewed talking about Young Thug.
Brian Steele, thank you so much for making time for us today. How you doing?
I'm okay. How are you?
I'm doing well. You know, let's start off with the national conversation that's happening right now about rap lyrics, whether they should be allowed in courtrooms during cases and whether they should not be. We know New York is having this discussion. Fulton County is having this discussion. You know, LA, so many courtrooms nationwide. What are your thoughts on that?
I don't believe that unless the lyric has a direct relation to the supposed crime on trial, and there's evidence to support that, the fact that somebody has created words that are in a song or in a book or in a movie, they should not be judged by their work, performance, because that's storytelling. So the problem I really have with the lyrics from rap music,
watch this,
throughout our country and right here in Fulton County, is we don't do that with other types of entertainment.
If Brian Steele just told the truth, I need you to like, subscribe, comment. I need you to hit a one in the chat. Listen, if that man did not just tell the truth, if you believe Steele just told the truth, put a one in the chat, because we're gonna listen to that again. I need to see a bunch of ones. That man told the unadulterated truth.
Be judged by their work, performance, because that's storytelling. So the problem I really have with the lyrics from rap music throughout our country and right here in Fulton County is we don't do that with other types of entertainment or artistry. And that's really my problem, because to me, rap music has been birthed by the struggle of the inner city, poverty-stricken, oftentimes people of color. And why are we targeting that group?
What did he say? What word did he use? Y'all thought I was playing. Why are we targeting? What did that document say without saying the word target? He's cunning, man. Brian Steele is cunning. Now he has evidence. Now he has allegation to believe that his client is being targeted. Chantry says that that's a fact. They don't do that with other genres of music. That's 100% real talk.
Or artistry. And that's really my problem, because to me, rap music has been birthed by the struggle of the inner city, poverty-stricken, oftentimes people of color. And why are we targeting that group rather than a writer who talks about a killing or drug dealing? Or how about the white songwriters?
How many Stephen King novels have a lot of death in there, right? Basically, he's saying that it's just it's entertaining. It has levels of, you can find truth in a lot of things. Even in your imaginative writing, you can find an element of something that could possibly happen. But that doesn't mean it gives you motive to do it. Just because you were able to write this out, it doesn't mean that you would do it. It's just what's happening in your mind. But there has to be some elements of some truth or possibility in it. Otherwise, why are we watching movies? Why would I watch a movie if it doesn't have an element of possibility? Just the other day, not so long ago, I watched The Beekeeper. It was Jason Statham went nuts in that movie. But is he going around kicking people upside the head? And if he did kick a man upside the head, isn't there a violation or something that has to happen before he does that? He ain't just walking around just kicking people upside the head. So you think because of the lyrics in a song that these people are doing what you think they're doing, and so now you're using lyrics that's used for entertainment industry as evidence. You can't build a case that way.
That group rather than a writer who talks about a killing or drug dealing. Or how about the white songwriters?
Why does rap music oftentimes feel like it's on trial as a genre?
It seems like it's racist to me. Because otherwise, I have no idea. I don't know why other forms of violent lyrics in country music or in rock and roll, they don't seem to get this type of attention.
Where do the lines blur when it comes to lived reality and that storytelling that we speak of? Because that's something that's also argued is like, okay, is this someone's personal diary, or is this them telling a story from a lens that they're storytelling through?
Unless there's direct evidence or circumstantial evidence that's credible and that's competent in a courtroom, this is storytelling. Otherwise, if you look at it the other way, it's going to have a chilling effect on creativity.
When you got the call to represent Young Thug, as an attorney, what was going through your mind at that time?
And I'm concerned with a human being who's wrongly charged. And I've had the pleasure of defending Mr. Williams for approximately a decade, maybe a little more. So to me, I know his family.
A decade. You hear that man said? He been representing Thug for a decade, bro.
Thug. As an attorney, what was going through your mind at that time?
And I'm concerned with a human being who's wrongly charged. And I've had the pleasure of defending Mr. Williams for approximately a decade, maybe a little more. So to me, I know his family. I've defended him in courtrooms multiple times. I knew right away that he's been targeted for 10 years by the prosecution. So
targeted for 10 years, man. Can you imagine? Can you imagine how much money that they have spent to get somebody? Taxpayer dollars is going towards this case, and I'm still looking for evidence. Okay. I'm sorry, guys. I'm looking for actual evidence of anything that is illegal under this organization called YSL. Evidence. D Pill, appreciate you. It's sad the judge allowed rap music in to use against they used lifestyle, a song, as evidence. If you're reaching, you're reaching. You're absolutely reaching. Now it's so funny. What's my crazy dude, the crazy white guy that got the British wife? I forgot his name. The one that bit the bird head off on stage. Somebody help me out in the chat real quick. The man that bit the a bird head off on stage, and he had that reality TV show. His wife, they're British. He's a heavy metal crazy guy. It'll come to me in a minute. He has been showing like indecent presentations at his concert for years. Nothing ever happened to him. Nothing. He's actually gotten richer. Osborne. Thank you, Silk G. Chamberlain. I appreciate you, my brother. Osborne. Oh, Ozzy. Oh, Ozzy. Oh, coked up Ozzy, man. The dude is a basket case at best. And guess what? No one's tampered with him. He bit the head off of a bird, man. Oh, man, let's go. Let's keep going.
My feeling was exactly what I said, that this is a wrong prosecution and I will defend him.
What do you feel like he's being targeted, or he has been targeted for a decade?
Every time it's a bad stop by the police officer. It's a unlawful search warrant. It is some charges that there were multiple people there and he had nothing to do with it. So how many times do you have to be wrongly prosecuted till you realize that he's being wrongly targeted?
How hopeful is he right now in conversations? We did hear the video that he made to his fans during a concert where he directly talked to his fans. But how is he doing right now with everything that he's going through?
He's an amazing person who comes from hunger and poverty and lack of opportunity. He's extremely strong and he's getting stronger every day now.
The indictment received new charges recently. Is that new evidence that came about? Where did the 6 new counts come from?
On the day of Mr. Williams' arrest, which is going to be Monday, May 9, 2022, law enforcement officers execute a search warrant on the home that he stays in. He stays in many homes. And in that home, allegedly, there was marijuana found, codeine found, and guns. One gun, a supposed machine gun. That's the allegations. There were several people. I don't remember the exact number, 8, 10, 12 people in the home at that time. There's multiple people in and out of that house other than Mr. Williams. So what law enforcement officers did was they then charged Mr. Williams with these additional crimes. As you said, the indictment was already out, and now the prosecutor just added those charges to this indictment.
And with the charges that are listed, which are, very serious, you're saying your client is completely innocent.
Mr. Williams is wrongly charged on every single count. I think,
dude, I'm telling you, whether I was guilty or not, bro, I need a lawyer like Steele. Steele has to be my lawyer, man. He looked that woman dead in the eye, just like Bill Clinton did all of us back in the 90s, and said, I did not have sexual relations with that woman, Miss Lewinsky. I didn't tell nobody to lie, not one time. She said, this man is innocent. Mr. Williams ain't did nothing. Listen, whether I'm guilty or not, just write Steele in the chat.
Which are very serious. You're saying your client is completely innocent.
Mr. Williams is wrongly charged on every single count. I think that a person like Jeffrey Williams is a hero, not a criminal. And January 2023, all of that will be told.
Can you give us examples of his community service and commitment to his community?
What up, Doe?
He's done multiple concerts.
What
He
up,
donates
though?
every single penny to the inner
EPJ,
city.
I appreciate you.
He has come to relief of cities and communities that have been devastated by whatever it is, violence or some sort of flooding or whatever. He'll put on a concert and donate all the money to those communities. He has brought into communities open house. Just go to the store. They will give you all of your food and your clothing and the children's back to school needs. He's come into communities with hundreds of pairs of shoes. Just show up and then find the shoes that fit you. He has given
Miguel Rodriguez, this is old bro. Find something new. I appreciate your comment, but you haven't been at the start of this. We are dissecting the attitude, the representation of Brian Steele and the way he talks about Jeffrey Williams, who is Young Thug. We was reading his supplemental motion to recuse Judge Glanville, and in that motion, he has written it poetically. And we are looking at the fact of how your attorney talks about their client. By the time Steele is your attorney, you will be a saint. You are a pillar in society. This is the representation that we're referring to. So this is what we're talking about. All right. So I appreciate the comment. I understand. I know this is old. I know that that's you didn't say anything brand new. We know. Okay. We're looking at this specifically for one particular reason. So appreciate your comment though.
been jobs to people only in the inner communities. He'll only hire from the inner communities in his studios or his rap label. He has promoted and hired and signed artists only from the inner cities to do rap. And he has gone to children and not only sponsored the cheerleading and the football team and the basketball team and the baseball team, but he goes and explains to them, don't be a rapper. Go to school and go get a degree and be a professional. And he tells everyone that. There's this young man named Corey Jackson, Corey J. If you ever Google him, you will see what Mr. Williams does. He does it countless times, where he takes a child who's basically homeless and their family, and he doesn't want any credit. And that young man today goes around our country. He's 15. He goes around our country and he tells people, hustle doesn't mean sell drugs. Hustle means get up every day, put on clean clothing as best you can. Let's get an education. This is what you do with your money then. If you're ever lucky enough to get money, don't gamble it away, invest it.
Tell us about how important it was to hear Corey J's personal experience with Young Thug in the courtroom, that heartfelt message that he shared.
That's just Mr. Williams. I could bring countless people like that. This is just Mr. Williams.
I'm telling you, man, Brian Steele's now watch this now. As we take a look at this, Brian Steele, his demeanor, his poise, his calmness, his ability to still be assertive and not be disrespectful. This is the man who has called Judge Glanville a man who has presented misconduct to the court. He called them an actor. This is the man. This is the reason, Miguel, if you still watching, my brother, this is the reason why we're watching it. This is the man who is now saying all three of these dudes, all three of y'all, Lawyer Love, Lawyer Hilton, and Glanville, all of y'all number some actors. Y'all strolled into the court after an ex parte meeting like nothing happened. Y'all some actors. Y'all got this man hot. And let me tell you something about calm people. It's some calm people that will whoop yo. All right. You're gonna be calmly knocked out if you keep poking the bear. And I think that's what happened. I think they poked the bear, and now we're not getting this. We're not getting this Brian Steele no more. At first, it was, Your Honor, Your Honor, I mean, this honorable court, Your Honor, thank you so much, Your Honor. I appreciate it. Now is get Glanville out of here. Get Glanville out of here, man. That's what's happening now. It's no more calm, cool, collected still right now.
When you're dealing
and you
with,
fought for Corey to be heard. I remember, the judge was like, hey, is this a different kind of voice that we haven't heard yet? You were like, let the kid talk. Like, if he can have an opportunity to be heard, let him get up on the stand and to be heard. How important was that to you?
it's important because the court is hearing the prosecutors say that Mr. Williams is in charge of a criminal street gang, and by his word, people can die. That's basically what he's saying. And that's just not true. So I thought that everybody that we put up at that bond hearing is important for the court to know about and a jury to know about.
Why is Mr. Williams so relatable to the youth in Atlanta?
Because he is the hope. And he's trying to get others out of poverty. That's his mission in life.
What are the negative connotations that comes with being a rapper that may not always reflect who the rapper is?
For people like you who are informed, people in the rap industry, it's show business. It's an act. They are performers.
Hold on, sorry to stop you. That's a fact, DPJ. He also, he refuses to call Glanville honorable, and which you got to respect him. He is totally against Glanville. It's almost like that. It's like it's an maniacal type of thing now. You can tell it's becoming a thing of more like now we're taking a stand for something, because this judge is now causing us to look like we have no integrity. This is the court. This man is talking about the country looking at us like there's no integrity in the judicial system, period. All right. In the entire system, which, hello, it's been an asterisk on the judicial branch since the beginning of time. If we keep it a buck, you know what I'm saying? So the fact that he's rocking like this now, opposed to this back then, look at this. This was years ago when he was cool with it. His presentation is on point. Now this man he's salivating at the mouth to get rid of Glanville. Salivating, man.
So, and they're performing all the time, much like, I guess, professional wrestlers. We don't even know their real names. They're performing all the time. That's not the human being, though. That's not, them with their family members or with their community members. That's what you're asking. So for people who say there's a tweet, Young Thug, that says it all, those people are really misinformed, and I expect that they will change their opinion if they're interested in learning come January 2023. Because Jeffrey Williams is a father. He is a son. He is a genius, and he committed none of these crimes.
When he in a courtroom is being called King Slime, that the allegations of YSL is connected to, according to prosecution, street gang activity, of crime, of felonies, of all these different things. Tell us about what the next few months really means to you.
We spend every day working our case. And putting it into
what the hell I'm talking about. That's what the hell what I'm talking about. Work that damn case every day. Every day. This is the lawyer you want. Every day we working on our case. The state is not doing it. I'm gonna tell you something. I'm gonna be honest with you. I'm gonna be real with you. And shout out to all the mods right now that's rocking right now. And I mean, DPJ, I appreciate you. Man, shout out to everybody, yo. This is absolutely fantastic. I shout out to Abundance, man. Appreciate you, you know what I'm saying, putting in the Cash App. I appreciate that. I wasn't even, I appreciate it. Look, I'm telling you right now, I have this strange feeling, and rock with me on this if you want to. All right, if you don't agree, that's fine. That's cool. I have a feeling that DA Hilton don't really like love. And I also have a feeling like somebody in this prosecuting office, somebody in the DA office about to turn criminal defense attorney. And it might be Hilton, because I'm telling you right now, the way Love is, you can tell she is terrible to work around. You can tell she is terrible to work around. You can't even do your thing. You cannot even prosecute the way you want because you got somebody in your face trying to tell you what to say, how to say it. Ask this question. You know what? Say this. Say this. I can't do my damn job because you all in my face. DPJ said the fact that the prosecution told the judge to close his, and the judge didn't say a word, tells you everything you need to know about the corruption. Hello. You might want to close your ears for this, judge. Even if you said you murdered someone, or I'm sorry, Abundance, unalived someone. Even if you unalived someone, you could, if you say that, you won't get prosecuted for it. If you did that back then, you won't get prosecuted for it. Really? You're gonna tell the witness that you gave immunity to. And again, we don't know if it's total immunity. We don't know if it's use, derivative use. We don't know. It's a lot of different types of immunity. We don't know if it's a state-based immunity or federal immunity. He don't have federal immunity. I know that for sure. That's a fact. He ain't got that. We could X that out right now. He do not have federal immunity at all. That's for sure. That's for dang sure. Abundance says the DA nor the judge have any integrity. That's a fact. DPJ, you got some tremendous insight because I was thinking the same thing, but I didn't know how to word it. Hey, I got you, man. I got you. So we're trying to figure this thing out here, man. And so this is the reason why I wanted to talk about Brian Steele real quick, because Brian Steele, to me, is representing Thug in a way that any person in their right mind would want their lawyer to represent them. If you got any sense, you want a lawyer like Brian Steele, straight up. You want a lawyer like Brian Steele. All right, we're gonna get back to the ex parte. I'm sorry, the documents real quick. Is it stupid to say unalive in these subtle words? Everyone thinks their mind anyway. Well, the point is that there's a community guideline with YouTube. So there's certain things that you will say and other people will report you. And so to stay from getting reported, you can substitute words. That's all. That's all it's for, man. So I understand it is stupid. I agree with you. It's very stupid to say unalive. However, you know what I'm saying? But that's what we have to do according to the YouTube. YouTube don't play about the community guidelines. I'm just telling you that right now. Okay. So trust me. Unalive it is, my brother. BJ, unalive it is. All right. Yes. Have you noticed the tension between them? Love and yes. The tension between them is ridiculous. It's there. It is there. It is not going anywhere. It is right there, man. The tension is crazy. All right. I'm going to switch up a little bit here. We're going to go ahead and get this back up. All right. If y'all enjoying the show, man, shout out, man. Just hit the one in the chat if y'all enjoying yourselves real quick. We about to go ahead and get into the rest of this document. It gets better. It says here in the case at bar, the court met ex parte with prosecutors and swore witness Copeland, and never intended to reveal that ex parte meeting occurred to Mr. Williams and his counsel at all. They came in there. Remember we read this earlier, and he said they strolled in to the courtroom and they wasn't gonna say anything. Appreciate the ones in the chat, y'all. Appreciate the one in the chat. Right. They say unalive. Exactly. Says the court has become part of the executive branch prosecuting Mr. Williams. Moreover, the prosecutors have abandoned and violated their ethical duties by engaging in this ex parte meeting and sitting silent while the court held undersigned counsel in contempt, and failed to reveal any Brady evidence from the meeting, including the fact that this meeting occurred, period. They never even said anything. The court and the prosecutors should not be working together, but they are teaming up to gain an unlawful advantage over Mr. Williams, and Mr. Williams' trial is constitutionally fractured, unfair, and lacks all constitutional, statutory, and ethical safeguards, and protections of due process of law. So it's going against all these things that we are supposed to have the right for, right? And when it comes to court, the court is biased against the accused and his counsel. Now, again, we just saw this, even though the clip was old, but we saw Brian Steele even say a few years ago, they have been targeting Mr. Williams. I was Mr. Williams' lawyer for a decade. I've been his lawyer for a decade plus. So they're targeting him. I know they're targeting him, right? No intellectually honest person could believe that coercing witness Copeland to testify in a star chamber setting meets constitutional muster. The court has failed to follow the lawful path. Instead, the court has unlawfully become the prosecutor, judge, grand jury. Why does that even sound like a snag, right? That's a snub, but I don't want to read too much of that. But really, grand jury, like Glanville, grand jury, the Gland. Now he's the Gland judge, grand jury. Judge Earl Glandry and his boy, man. Biased, partial, potential sentencer, and thus must be removed from this case in toto instanter. Toto instanter means immediately. On the motion to disqualify or recuse, it is the duty of the judge to pass only the legal sufficiency of the facts alleged and to ask whether these facts support a charge of bias or prejudice. Neither the truth of the allegations nor the good faith of the pleader may be questioned, regardless of the judge's personal knowledge to the controversy. The test is whether, assuming the truth of the facts alleged in the attached affidavit, a reasonable person would conclude bias exists on the part of the judge. And then he also cites some more cases. The court's conduct raises a strong finding that it has become personally embroiled in the case. Man, it is clear, even to a casual observer, that this court's involvement in this controversy requires this court to be disqualified, recused, removed from all further proceedings in the above referenced case in Stanter, and another judge who will duly exercise the powers of the judicial branch with partiality, clarity, and fairness must be appointed to this case. Let's see here. It's a lot of good stuff here, but I want to go to this right here, though. We're going to get into this real quick. Kablewski. Remember, Brian Steele was held in contempt. This is the actual document. If you have never read this, put a 1 in the chat. This is the document that was filed by one Chief Judge Pituitary Glanville. This is my first time actually seeing this too. I'm gonna be honest with you. That day, everything happened so fast and it was so unbelievable. I even forgot that he e-filed that boy. I ain't gonna lie. I'm not even gonna lie, yo. Like, I forgot that it was even a document for it. I am 41 years old. I have never seen a lawyer be held in contempt and also arrested in the courtroom. They made him take off his tie, his suit jacket. Oh man, order of contempt and incarceration for Brian Steele. Jesus, this is absolutely insane. During the proceedings in the above style case on the afternoon of June 10th, 2024, one of the two representatives for defendant Jeffrey Williams, Mr. Brian Steele, took to the podium and stated to the court that he had been informed of an ex parte communication which took place in the court's chambers that morning. The only parties present for this ex parte matter were the court, the court's official court reporter, representatives from the state's witness, Mr. Copeland, and counsel for Mr. Copeland. No, them other investigators in there too, my brother. But representatives of the state, he gonna just that's covering everybody. Huh? In addition to the court's serious concern with how this information was improperly disclosed to defense counsel, Mr. Steele made several claims regarding the sum and substance of the communication that the court found troubling. If you notice that day, all the things that Brian Steele said right before Judge Pituitary Glanville gave him 5 minutes. I'm gonna give you 5 minutes. I'm gonna give you 5 minutes to think about what you're doing. No, you got 5 minutes. And what Brian Steele said, Judge Glanville never challenged what he said. All he wanted to know was, who told you? What's the name? What's the name? He never said anything. He never said what you're saying is a lie. A lot of people was tripping. And I'm like, hold on. This is the most important part. Let me tell you something. If you tell him this is the way this went down was crazy. Because he's like, there was an ex parte meeting. He was like, wait. How you found out about that? And you just admitted that you was on some goofy, right? And now I caught you on your goofy, and you like, well, who told you that? Ladies and gentlemen and ladies, have you ever been in a relationship and you have speculation that someone is cheating on you? But then when you get cold evidence, clear evidence that they're cheating on you, and you confront them about it, they be like, who told you that? Who told you about that? Who told you? Wait, I was over Reggie's house. I was over. You was caught red-handed, bro. And he like, wait. Who said that? How you found out? That's exactly what that was. That's exactly what that was. Right. Then he said it was parroted. Exactly. Like, no. You just admitted that everything that Brian Steele said was true. You admitted it without saying it. But the fact that you did not even regard what he said, all you cared about is how he found out. You didn't stop him from talking. You didn't do any of that. All right, let's get back to it. I'm sorry, I'm flying off a little bit. In addition to the court's serious concern with how this information was improperly disclosed to defense counsel, Mr. Steele made several claims regarding the sum and substance of the communication that the court found troubling. What you mean? Like the fact that he found out about the email, the fact that he found out about, what was being said in the meeting? Really? You talking about that? Look at that. Right. It's what he didn't say that admitted his guilt. Exactly. My mother told me one time, she said, there's a few ways you can tell a person is lying. First of all, they're doing all the talking. They're trying to create their story as they're talking, which is the reason why I said in the last video I did, I believe I talked about how I think that they were trying to build their case. This is what I think the state is trying to build their case as this trial goes on. I don't think they already came with a case, had some facts, and then boom. So my mother told me, she was like, They're gonna be doing all the talking. That's number one. She said, and then also when they do all the talking, listen to what they're not saying. What they're not saying is what they don't want you to know. They're omitting as they speak. And that's exactly what that ex parte transcript was. It was a bunch of omission. It wasn't technically redacted, see, because you got to have those black lines to actually redact something. But what they did do was omit some stuff. And you could tell because it was too jumpy. You're talking about one thing. You're talking about one thing about Woody being a witness or how he could, or his immunity and what that means to him. And then the next thing he's saying is, I did these crimes. How did we go from you talking about what immunity does to he did some crime? Who was talking about crimes? And then in between that, you had an emergency, a 2-minute emergency in chambers. It was 2 minutes, 10:45 to 10:47. And then all of a sudden, now he's talking about I did these crimes. When were you talking about crimes? When? That's called omission. All them dashes were suspect. Let me tell you something. When you look at a court report like transcript, sometimes they even write down the cough that a person does. They'll say undersigned counsel coughing, and then they'll start typing what they said. Everything about that transcript was suspect. And I played the video. The video that got over 50-some thousand views now. Okay. I played the video, and the video, as soon as was everything in the transcript, you know that. No one, your silence sometimes is louder than your words. In addition to the court serious concern, okay, we read that, made several claims. The court, having told Mr. Steele multiple times that he needs to tell the court how he came into that information. And the court having explicitly warned Mr. Steele that he faces contempt of court should he not comply. The court finds Mr. Steele has repeatedly refused to follow the court's order. First of all, asking me how I found something that is not an order. This ain't no order. That wasn't no order. That's number one. Number two, you still haven't disagreed with what that man said. you still haven't disagreed with what that man said at all. Okay. Every court has the power to compel obedience. Glanville, what, man? Every court has the power to compel obedience to its order and to control the conduct of persons connected with the You can't control my conduct, boy. You can't control how I act. You can't control, I can compel obedience. Stop it. One who disobeys an order or command of the court may be found in criminal contempt. Now you went from that day that was the day he didn't know the difference between civil and criminal. Your girl Ashley Merchant had to come through. Your girl Merch Patrol was on. Ashley Merchant came through like a boss. I ain't gonna lie, man. She came through. She was stating facts to him and my man Ponytail. Before a person may be held in contempt for violating court order, the order should inform him definite terms as to the duties thereby imposed of him, and the command must therefore be expressed rather than implied. Since the question of whether contempt has occurred is for the trial court, and its determination will be overturned only if there has been a gross abuse of discretion. Once an act has been determined to constitute contempt court, the action the court takes to deal with the contempt determines whether the contempt is deemed criminal contempt or civil contempt. The distinction between criminal and civil, he using Ashley Merchant's definition now. The distinction between criminal and civil contempt is that criminal contempt imposes unconditional punishment for prior contempt to preserve the court's authority and to punish disobedience of its orders. Cited another case, cited a quote from that case, another case. Accordingly, it is hereby ordered that pursuant to court's authority under OCGA, the court holds Mr. Steele in direct criminal contempt for failure to comply with the court's order. It seems like this court just throw things at the wall, just hope that it sticks. They don't, I mean, they just do whatever. This is ridiculous. It is further ordered that Mr. Steele has been taken into custody of the Fulton County Sheriff and incarcerated at the Fulton County Jail for no more than 20 days for this contempt, with those 20 days consistent of every weekend for the next 10 weekends. Mr. Steele is to report to the Fulton County Jail. Man, that's crazy. On 7 p.m. on Fridays, will be released 7 p.m. on Sundays. Mr. Steele's incarceration is to start this Friday, June 14th, 7 p.m. and is not to end until Sunday, August 18th, 2024, 7 o'clock p.m. Subject to further order of the court. So ordered June 10th. And he called himself the Honorable Rural Glanville Chief Judge. Now we all know what happened with that, right? Supreme Court said, nah, buddy. Nope. I don't think so. Hold up. Wait. Exhibit B. Let's get into it. This is the affidavit. All right. Let's get into this affidavit real quick. Yep. Let's get into the affidavit real quick. It says here, joint affidavit of Brian Steele and Keith Adams. Again, I have not read this yet, y'all. So we all doing this together. Before we do that, DPJ, appreciate you, man. Who you think the mole was? I think it was Melnick. I think Kayla told Melnick after the secret meeting. Then Melnick told Brian. But truth be told, like Brian said, Judge, you should have told me. That's a fact. I don't know. If I had to really guess and think about this, I would probably say that what you're saying might have a little bit more possibility than Caleb Bumpus just telling Brian Steele, because Caleb Bumpus has already admitted that when the ex parte meeting happened, she went straight to the courtroom after it was over. Brian Steele had already knew about it before she came up to him. So she did not technically see these lawyers, man. These lawyers, dog, she did not technically tell Brian Steele what happened in chambers. Brian Steele, according to what she said, and I quote, Brian Steele came to me and said, I'm probably going to jail today. That's what she said. So she did not technically tell him directly, like, yeah, this meeting we had, boom. Brian was already on it. All right. So now how he got it, I'm more curious about how he got it. If it's through text or email or something like that, I don't know. But Kayla telling Melnick, probably like, cause she went to go do him a favor and like, yo, I'm doing you a favor. Now I'm caught up in this. I'm about to get held. I'm about to get held in a motion towards me from the court, because they think I got to come to a hearing because they think I said something. You know what I'm saying? I'm here to make sure that what we talked about goes through. So that's what I think is probably what happened. So I'm leaning closer to what you're talking about, actually, because that makes more sense to me, due to the fact that from the time frame, Caleb Bumpus never was able to talk to anybody yet. You know what I'm saying? Until she went out to the court. They did see them on camera, and all that kind of stuff. But I think Melnick was the one that probably said, hey man, y'all got my homegirl over there going through. You know what I mean? All right, let's get back to the affidavit, man. Hope I answered your question. We are over the age of 18 and suffer no legal disability. We make this joint affidavit based upon our personal knowledge. So an affidavit is basically a written legal document of fact. All right, a written legal document of fact. Okay. We are counsel for Jeffrey Williams in the above style case on Monday, June 10th, 2024, and therefore affiants learned the following events in fact occurred outside of Mr. Williams' presence and outside of affiant's presence and in star chamber like environment. All right. June 10th, undecided affiants, specifically Brian Steele, asked to have a transcript of whatever conversations were memorialized, and affiants requested the actual recording of anything discussed at this improper in-chambers meet. Oh, okay. So he did ask for the audio, the actual recording of it. You think he's referring to audio recording, or just all the recordings in general? Yeah, I agree with that, DP. That she told Melnick, yeah, but she never told Steele though. But yeah, I guess technically that would make her mole-ish. But I think she did probably tell Melnick. She had to. She was caught off guard with that hearing, that hearing motion that Glanville gave her. The court has obstructed Mr. Williams and below affiants from having an exact image of what was said. This obstruction alone shows that this court is biased, as there is absolutely no privilege and communications in this court's chambers, as this court argued on June 10th, 2024, and there is certainly no attorney-client privilege under any stretch of the imagination, as this court asserted. This obstructionist conduct by this court shows bias in that this court asserted, shows bias in that this court is intrinsically intertwined in the facts of this case and has prevented Mr. Williams from due process, Lord have mercy, fair trial, effective assistance of counsel, right to know every material and critical happenings in his case. Critical happenings in his case. What that mean? He said the exact image. So, for instance, like a photo of you is an image of you, but you yourself you are the expressed image of that photo. He wants the expressed exact image of what happened in that chamber or in that star chamber. So that's the difference. He don't want something like a photo. Yeah, that's you, but that's not. I want the expressed image of you, and that's what he wants: the expressed evidence of what happened in those chambers. All right. Further, this court, by its words used on the record when speaking in open court with affiants, as well as the court's silence, as well as lawyer Love's statements in open court, clearly demonstrates the facts below are true and accurate. The court has also silenced witnesses by improperly issuing a show cause order, right, for contempt, and thus making all witnesses in fear of going to jail. Ooh, let's go. If the truth is told about this improper violation of Mr. Williams' constitutional right to be present at every critical stage of his trial, fair tribunal, effective assistance of counsel, due process under the law, the right to make a record in the case. This court is biased and must be recused. Further, the cross-examination of Mr. Copeland will include facts that occurred at this star chamber meeting, which puts the credibility of lawyer Love, lawyer Hilton, this court in issue, and this court should never be the person who is in charge of the Lord, man, Steele is gone. When the court's conduct is being questioned based upon the courts and lawyers for the state of Georgia's actions, Mr. Williams has been put into a trick box by the misconduct of lawyer Love, Hilton, and this court. This is my first time reading this, y'all. This part right, I mean, it's 223 pages of this, okay? You see that over there, right? That's a real number, okay? This court must be recused, a mistrial declared, barred by double jeopardy based upon prosecutorial misconduct and judicial misconduct. Okay, he wanted overturned all the way. He's like, look, bar it from even double jeopardy. Don't even bring it back up. Completely remove it. Mr. Kenneth Copeland, a witness, had been called by the state and sworn on Friday, June 7th, and who invoked his Fifth Amendment and was held in civil contempt by this court. was brought to the Fulton County Courthouse on Monday morning, June 10th, 2024, unbeknownst to affiants, Mr. Williams, or anyone else on the defense side of this case. This court met in its chambers with Mr. Copeland, his counsel, Lawyer Love, Hilton, and at times court reporter Weaver, as well as sheriff, deputies, and other persons. So yo, man, this is like super disturbing, man. If you really think about this, this is very disturbing, man. This could happen to any of us. For real. Very, very disturbing. Deputies may have been instructed to turn off their body cameras. What? Okay, now, again, remember, this is a supplemental motion. So there's going to be a little bit of speculation in here too. So deputies may have been instructed. Okay, he's using his words very carefully. He didn't say deputies were instructed to turn off their body cameras. That's a different statement. All right. Saying deputies may have been instructed to turn off their body cameras, that's speculation. All right. So that's alleged. So he's I mean, still is on it, man. But that is possible. That is very possible. Because it is ex parte. So by definition, it's not supposed to be recorded at all anyway, in any form, except for by the court reporter. There was and is nothing privileged under law about this improper ex parte meeting. This court and others met with Copeland for a lengthy period of time. Remember that day? This is go back to that day for a minute. I mean, court didn't start till like 11:30, almost noon, man. Everybody and their mama was waiting in the chats all over the internet. Because this was the key witness. This was the guy. The total ex parte meeting lasted for more than 1 hour, approximately 2 hours, because they got there at 8:30. With the above named people at the meeting at all or various times, Mr. Copeland continued to make known his assertion that he would not testify, even in the face of being held in contempt and in order to testify under use immunity. We found out what kind of immunity he had, man. He had use immunity. This is why you got to read it all the way through. This is why you got to read it all the way through.
Him cook now.
Yeah. Let's play, baby. Yeah. I was trying to figure it out. Thank you. Thank you, Brian Steele, for letting us know what particular immunity he had. He had use immunity. They did not give that man total immunity. Oh, man. This is awesome. Okay, this is good. This is good. This is good. Okay. This is good. This court and lawyer for the Fulton County District Attorney's Office, Love and Hilton, ignored Mr. Copeland's decision and continued to declare to Mr. Copeland that he would be held in custody until he testifies, or alternatively, if he persists in refusing to testify, he would be held in custody until not only Mr. Williams' current trial resolves, but until all 26 indicted persons' cases are resolved, whichever is longer. Let me ask you a question. Don't that sound like coercion to me? I mean, just put coercion in the chat. If you still here, you rocking with me, I appreciate you. First of all, I appreciate y'all rocking with me on the day, because again, we still celebrating as well over 500 subscribers. So I appreciate all the mods and everybody watching right now. I don't mean to neglect you. I don't want to neglect you, but this is getting really good now. This is really getting good, because we're starting to see some things that we were all speculating. Now it's actually fact here. All right. This court was a participant and was present during these admonitions, threats, to Mr. Copeland. This is witness intimidation. Yeah. Prosecution to induce a material witness to testify. This court, lawyers Love, Hilton, are now all witnesses in this case and will be called by Mr. and or possibly other accused so the jury can determine demeanor and credibility of what occurred at this in-chamber meeting. That's right. The jury don't know, allegedly. They don't know. Remember the jury, they say, hey, y'all can go. They've been gone since June, end of June. They have no idea that this all is going down. Again, allegedly. Because even though they say you can't look at YouTube, we know them people looking at YouTube. Come on now. Come on now. Come on now. They looking at this. They for sure looking at this. Okay. Come on now. They for sure looking at this. Drop down for a minute. There we go. It says here that this court was a participant, right? So they're going to be called. This court, Love, witnesses. Please note that the witness list is hereby amended by this joint affidavit to include the court, lawyers Love, Hilton, and all other relative material persons that have information to share with the jury regarding the conduct, words, and actions at this ex parte communication. This court provided Mr. Copeland with a written copy of the statute on crimes of perjury as well as false swearing. This is not subtle gesture. This is no subtle gesture, and one that helped the prosecution team to obtain their mission for Mr. Copeland to change his mind and testify. Love made representations to this court in front of Copeland and his counsel, deputies, court reporter, and others that Jonathan Melnick, counsel for Mr. Copeland, committed misconduct during his representation of Mr. Copeland and was not representing the interests of Mr. Copeland. You damn right, man. Remember that? So who is he looking out? The interests of his client or the interests of Mr. Steele's client, who is also Jeffrey Williams? Because why isn't he here? If he cares about his client, then he should be here. Not realizing that they already just had certain arrangements and agreements before Lil Woody even got there. When Lil Woody decided to testify, there was already paperwork drawn up that Caleb Bumpus had that in case he decided to testify, that he would do a noisy withdrawal from representing Kenneth Copeland. What is a noisy withdrawal? That means he was not going to be able to ethically represent him fully and properly, because remember, the state talked to Lil Woody without his counsel. And remember, Melnick had already been representing Woody for about 2 years. And he told them, I kept telling them I'm not going to testify. I kept telling y'all all week long, on Thursday, Friday, on Saturday, on Monday, Tuesday, Wednesday, Thursday, I wasn't going to testify. So they tried to, again, coerce, intimidate by talking to Lil Woody without his counsel present. And now all of a sudden, they want to act like Woody said, he told us he ain't had no lawyer. That's a lie. Because even in the 2021 leaked video that came out before they even had a jury pick of Lil Woody having a 2-hour interrogation with one of the couple detectives, he even said, the detective said, do you still, who's your attorney? He said, Melnick. in that video. And that was 2021. Him and Melnick had been representing him already. So all they did was try to intimidate him. These are knowing misrepresentations, by Lawyer Love to this court, which Lawyer Love continues to do, which biases this court in favor of the state and against the accused, their lawyers, and other members of the bar. Further, the court permitting Lawyer Love to speak ill of Mr. Copeland's counsel in front of Mr. Copeland adds to the coercion and witness intimidation. This ex parte discussion violated Mr. Williams' constitutional right pursuant to Article 1, Section 1, Paragraph 11 of the Georgia Constitution to be present at every material stage of his trial. The court and Lawyer Love and Hilton, speaking with Mr. Copeland, a sworn witness, about his testimony and whether he would change his mind and testify is clearly a critical stage of the proceedings. See Scudder versus State. As asserted in her motion to recuse, this court filed 10:40 p.m. on 14th of June. Attorney Bumpus, by her counsel, verified the below facts. These facts are adopted into affiant's affidavit. Okay, here we go. Buckle up. Let's see what's going on. These facts are assertions of Attorney Bumpus as statements of her lawyers. It goes as follows. On Monday, June 10th, 2024, at approximately 8:30 a.m., Mr. Copeland and his lawyer, Attorney Caleb Bumpus, were escorted to the court's chambers and conducted an ex parte meeting regarding whether Mr. Copeland would testify. Those present for the substantive portion of this ex parte meeting were Judge Glanville, Copeland, Bumpus, lawyers Love and Hilton, members of the court security staff and deputies, 2 investigators from Fulton County District Attorney's Office, and the court reporter. In chambers, this court asked Mr. Copeland whether he was prepared to testify. Copeland announced that he planned to again invoke his Fifth Amendment privilege on the stand. A conversation among the parties ensued regarding Mr. Copeland's understanding of immunity. How Mr. Copeland thought he may testify if he did not invoke the Fifth and certain facts of the case. Right, he was trying to figure it out. What happens if I don't testify? What's going to happen to me? Once Mr. Copeland learned that he could be held indefinitely by court if he refused to testify, not just 2 years as he initially believed, Mr. Copeland decided that he would testify. Mr. Copeland added that his testimony would be a lie. He said, I ain't never been honest in my life until right now, until what I just said to you. I just told you the honest thing. My honest thing is I ain't never been honest. I'm honestly telling you I've been dishonest my whole life. I'm letting you know that right now. I ain't never been honest. I ain't never scared, man. I ain't never been honest, man. This court never assured that this Brady evidence, still is on point. Can I just drop a clues? Can I just drop a clue? Still. And still. Man, this guy right here. This court never assured that this Brady evidence would be revealed to Mr. Williams or his counsel. And Brady evidence includes the fact that this meeting occurred. Instead, this court takes the position that no information about this meeting should have been revealed to Mr. Williams, his counsel, or anyone outside of the Star Chamber where same occurred. D. Peel says still standing on business. He's standing on business, man. Dude is standing on business for real. This shows that the court has become a member of the prosecution. A member of the prosecution team, excuse me. I take a little sip, a little dry mouth there. In an effort to thwart Mr. Williams' constitutional right to a fair trial and a fair tribunal and due process, and right to be present for each critical stage of the proceedings. Right to call witnesses, the right to present a defense, or right to cross-examine witnesses on critical topics, including facts of this case were discussed with the court during the intimidation of the witness. Damn. This court must be recused. The court and the prosecution have violated Mr. Williams' rights, and the indictment must be dismissed after a mistrial is declared, as the court and the state has goaded Mr. Williams into moving for this mistrial recusal of the court. This is about to get good, y'all. I can feel it. Everybody put a 1 in the chat if you're enjoying this real quick. We're doing 2 hours, guys. I mean, for real. Hey, yo, I got to say something, man. I appreciate you all for real. Y'all don't know how much it's mean to me. Y'all just don't know how much it's mean to me right now. I'm being real with you. Thank you so much. Thank you so much for being a part of this. On Monday afternoon, June 10th, 2024, at approximately 1:00 p.m., once affiants made the above known in open court, the court refused to release the transcript of this improper ex parte occurrence, held Mr. Williams' lawyer in contempt of court, ordered Mr. Williams' lawyer to serve maximum period of time in custody, all that bullshit. All in an attempt to intimidate Mr. Williams and his counsel from understanding and learning about the court's and the prosecution's wrongdoing. The court has become a material witness because undersigned counsel has the right for the jury to understand that this court met with Mr. Copeland and the prosecutors in order to convince Mr. Copeland to testify against Mr. Williams. Okay? Plain and simple. The improper ex parte meeting on June 10th with a sworn witness concerning the witness's willingness or non-willingness to testify, and this court giving the witness a copy of the law of perjury and false statements and discussing facts of the case, is unfavorable, unforgivable. This is not an ex parte meeting that the court has had with affiants ever. Never, ever, ever, ever. Remember that? Remember in the video? Remember when Glanville was like, you know, just like when you all have ex parte meetings with me, just like when y'all meet with me alone. Brian's still like, man, you know damn well we don't be meeting with you with no witnesses, dog. Still ain't playing with you. Says on the very few occasions that affiants have had an ex parte hearing with this court, affiants announced in open court that it needed to speak with court ex parte. There was no objection by the prosecution, and same occurred. Never was a witness involved in these rare ex parte meetings. Never. Affiants demand to question this court and the above lawyers for the DA's office as to how many ex parte meetings have they been, because we think it's been more. Appreciate the ones in the chat. Appreciate the one. Let me show the love real quick. Appreciate the ones in the chat. Appreciate you, Dove Cuz. Appreciate you. Appreciate you. Thank you so much. D Peel in the bit. DPJ in the building. Abundance. Low. Hey, less is more sometimes. You feel me? We are a mighty army in this boy. Let's go. Appreciate all of you. Okay, so we want to know how many ex parte meetings y'all done had, basically. The substance of those meetings, we want to know that, and who was present, and the like. Even if just one ex parte meeting occurred, as did on June 10th, this mandates that the court has forfeited its role as an impartial judge and has become a member of the prosecution team. The court must recuse itself. I mean, he is hammering that recusal like crazy. The court, on at least one occasion, has been fed improper ex parte information about facts of this case and a witness statement about this refusal to testify. The court met with a witness and spoke with the witness about the witness' willingness or non-willingness to testify, along with the prosecutors, and then held undersigned counsel in contempt when undersigned counsel simply wanted to know why he was not notified of this ex parte meeting. judicially and ethically prohibited meeting. Again, I just want to know, why wasn't I there? That's all. All I want to know is, why wasn't I there? The court has now placed the lawyer for Mr. Copeland and other unknown persons in a position that they need to come before the court on a date certain to give testimony as to who gave information to affiants concerning the improper meeting on June 10th, in the Star Chambers with Mr. Copeland, the prosecutors, the court. The court has become the executive branch. Brian still said the court has become the executive branch, man. Conducting an investigation as a grand juror, prosecutor. This court has lost all impartiality, and Mr. Williams cannot receive a fair trial with this court being present over the proceedings. This court has falsely and wrongly accused affiant, specifically Brian Steele, of being unprofessional and unprepared in front of the jury. They did say that. Neither claim was close to the truth or was accurate. We know who's prepared and who's unprepared. Trust me. Oh, we know already. The prosecutor sat silent, and as affiant was wrongly and falsely accused of improper conduct, they ain't even say nothing to your boy, man. This court has violated every neutrality, impartiality that it was sworn to undertake. Cited the case, even knowing that the court has falsely accused Brian Steele of being unprofessional and unprepared in front of the jury, the court has refused to instruct the jury to disregard the court's improper comments. I mean, damn, right in front of them. This clearly shows that this court is biased and impartial against Mr. Williams, and or is counsel and in favor of the state, as no fair judge would not correct such a serious misstatement made in front of the jury. The bias of this court is objectively proven. When Mr. Copeland took the witness stand on Friday, he refused to testify and was taken into custody. The court knew, as did the prosecution, they knew that he was going to refuse to testify in front of the jury, but the court did not reveal fact or take any action to stop Mr. Copeland's refusal to testify in front of the jury. Mr. Copeland's refusal to testify in front of the jury prejudiced, Mr. Williams a great deal, and the jury should never have heard Mr. Copeland exercise his Fifth Amendment right. This court told the courtroom deputies to prohibit the media from filming Mr. Copeland if/when the court ordered him to be arrested. This direction occurred before Mr. Copeland even took the witness stand on Friday. Dang, they already knew. They knew they might have about to arrest him. And oh my God, they already knew that they would potentially arrest this man. The court has harmed Mr. Williams by hiding this information from Mr. Williams, having ex parte communication with the deputy and media, and permitting Mr. Copeland to assert Fifth Amendment right in front of the jury. When the Honorable David Botts brought to the court's attention that he had evidence that the prosecution knew that Mr. Copeland was going to invoke his Fifth Amendment right in front of the jury. Wow. Okay, now we're going to go down to something a little bit here. We're going to get to some nitty gritty. What are y'all thoughts about this so far? What are your thoughts about this so far? I mean, this is pretty remarkable, right? In the Superior Court of Fulton County, I think this is exhibit. What exhibit is this? F. Exhibit F. Here we go. In the Superior Court of Fulton County, State of Georgia versus Jeffrey Williams et al. Chief Judge Earl Glanville, order compelling witness testimony pursuant to OCGA 24-5-507. The state of Georgia have moved this court pursuant to OCGA 24-5-507 to compel the testimony of witness Kenneth Copeland and District Attorney Fannie T. Willis, having determined that the testimony of Kenneth Copeland is necessary to the public interest. Okay, there's a footnote there. Where's a footnote? Okay, Kenneth, we're going to read those footnotes. Kenneth Copeland having been properly subpoenaed to appear before this court to testify, another footnote, and the state of Georgia having provided to this court sufficient reason in support of its motion to compel the testimony of Kenneth Copeland, another footnote that we will get into. This court finds that Kenneth Copeland has been properly subpoenaed to appear before this court to testify in the trial of the instant case, and that the testimony of said Kenneth Copeland is necessary to the public interest. Accordingly, it is hereby ordered that witness Kenneth Copeland shall appear before this court beginning Friday, June 7th, 2024, and provide testimony in the trial of the above styled case, shall continue to appear and testify until released by this honorable court. Okay, they were citing cases here for the first footnote. Okay. See Exhibit A, Certificate of Personal Service. Okay, gotcha. Okay. Further pursuant, said Kenneth Copeland shall not be excused on the basis of the privilege against self-incrimination from testifying or producing any evidence required. Shall not be excused on the basis of the privilege against self-incrimination. Wow. However, no testimony given by Kenneth Copeland as required under this order, and any information directly or indirectly derived from the testimony of Kenneth Copeland given by Kenneth Copeland as required under this order shall be used against said Kenneth Copeland in any proceeding or prosecution for a crime or offense concerning which he testifies under this order. Kenneth Copeland shall be subject to prosecution or penalty or forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify in accordance with this order. However, it is ordered that Kenneth Copeland shall not be required to produce evidence that can be used in any other court of this state, use immunity, the United States, or any other state. Finally, it is ordered that should said Kenneth Copeland refuse to testify after this order is entered, Kenneth Copeland, Lil Booty, shall be subject to being adjudged in contempt or arrested. Arrested of this court, and shall be subject to commitment by this court to the Fulton County Jail until such time as said witness purges himself of contempt by testifying as ordered to do so by this court. It is so ordered. This order shall be entered for the record in the minutes to this court, and any testimony given by Kenneth Copeland pursuant to this order shall be transcribed and filed for permanent record. And there's a bunch of I don't recalls in that, boy. I know that much. This was prepared by Adrian Love. All right. The Honorable Euro Glanville has signed it to order. It's the order compelling witness testimony pursuant to OCGA 24-5-507. Okay. Exhibit G. I think this is the order for recusal. This is the order for recusal. So basically, let's go back to a little bit, because let's go and talk about it real quick. Why was Fannie Willis mentioned in that particular order? Because she's the DA and she has to sign off on immunity. Okay. She has to sign off. Immunity has to go through the DA's office. Okay. So you better believe Fonnie Willis know what's going on in this case. That lets you further know that she knows. All right. This is the order of recusal. Superior Court Judge for the Superior Court of Fulton County, State of Georgia. State of Georgia versus Khalif Adams et al. The above style case is currently before the court on defendant Diamante Kendrick's June 12 motion. Motion to recuse Chief Judge Earl Glanville, non-party Caleb Bumpus, June 14th, 2024. Motion to quash order to show cause, and motion to recuse the court. This is what Caleb Bumpus is saying, right? It's about order. So yeah, we got that part. That's when this is the day that he said, you know what? I'm going to just remove myself from everything. This is the order. This is the judge submitting that order right now. Order, motion to quash, order to show cause, and motion recuses this court and defendant Jeffrey Witter. Motion to disqualify, recuse, and motion to for mistrial, which was golden. Under upon review and reconsideration of the upon review and reconsideration. I'm sorry for laughing. Of the recusal motions, it is hereby ordered and directed that these recusal motions to be heard by another judge pursuant to Uniform Superior Court Rule 25.1. The clerk of court is hereby directed to reassign the recusal motions to another judge pursuant to Uniform Superior Court Rule 25.1. So he recused himself. All right. Let's go ahead and keep it pushing. Here goes another one. Okay. Diamante State of Georgia versus everybody. Ones. Order requiring written response to recusal motions. So this case is before the court to consider motion recuse Chief Glanville. These are the three motions. We already discussed those things, right? Time is of the essence. Time is of the essence. Given that a jury trial is currently paused pending resolution of these recusal motions. Remember this? This was Rachel Krause. All right. Now we're about to go ahead. What are we about to look at? Exhibit I. What is Exhibit I? It's the email. Huh? It's the email. It's the email. Okay, now check this out, right? So we're gonna go. We gotta read this in order. So we gotta go down here to where it all started. All right. From Jonathan Melnick, Thursday, June 6th, 4:31 p.m. Adrian Love, Hilton, the Steele Law Firm, Mr. Sharp. Good afternoon, all. I was so excited about this right here, man. It has come to my attention that Fulton County District Attorney's Office has questioned my client, Kenneth Copeland, without my knowledge or consent. Without my knowledge or consent. Please be advised that my client does not wish to speak with any member of the Fulton County District Attorney's Office, nor any law enforcement officer from this point forward. My client will assert his privilege under the Fifth Amendment tomorrow and will not testify. There it is right there in the email. There's a reply. See that That's the reply. This is the ones that John has sent. But this is the reply to this. So here we got Miss Hilton replying. Good afternoon. I hope all is well. In our conversations with Mr. Copeland, okay. You just let us know that you talked to him. You just let us know that you talked to him. Appreciate you. In our conversations with Mr. Copeland, he advised that you were not his attorney and had not spoken with you. However, if you are asserting that you are his attorney, we will cease communication. Really? But your client is under subpoena and is expected to be here at 8:30. It is our understanding that your client does not have transportation. So we were planning to pick him up. Wait, what? Nah, hold on, cuz. Hold on, fam. Hold on, fam. Pick him up. No, you wasn't. You weren't about to pick up my client. Oh, hell no. Pick him up. We were planning to pick him up, so please make sure that he is present. So we do not have to take further action if he fails to appear for his subpoena. Thank you and have a great evening. Melnick said, hold up, wait a minute. Let me clarify something. I have been Mr. Copeland's attorney. He tells me that he repeatedly told you that when you were questioning him, I also spoke with Don Jury extensively about Mr. Copeland when he was assigned to this case, and I spoke with Ms. Love early in the process around the time jury selection was beginning. That was a long time ago, people. I have a plea with Judge Carnesali tomorrow at 9:00, and I will come to the court as soon as I am done, which is what he did. So they lied in the transcript. They said he imposed himself. Remember? Oh, they dirty. Damn. Ooh, I can't stand people. I'm sorry. I just cannot stand people like this. Y'all say he asserted himself. No, he told you I was going to come to the court right after I was done with a plea with Judge Carnesali. In the transcript, remember, if y'all all read the transcript, put a 1 in the chat. Put a 1 in the chat if you saw the transcript. It said that he barged in and imposed himself and got in between us and da-da-da-da. Yeah, because y'all got there at 8:30. At 9:00, you knew he had a plea, and he said he'll be there as soon as he's done. When he gets there, he sees you looking at his client, talking to his client without him yet again. You done did it more than once. You lying piece of... This is it right here. Wow. Evidence showing, this is Brian Steele's supplemental motion. This is evidence showing that they knew he was, they made it seem like he was some lawyer just randomly coming through, to save the day for Woody, when in actuality, he came for his client because he told you, I have a plea at 9. So that means you can't talk to you told me in the email that you was going to cease communication with my client. I found you again talking to my client after you said you was going to cease. Unbelievable. Okay. This is crazy, man. This is absolutely insane. That was the end of the actual motion that Brian Steele filed. Now we're going to look at another motion. And I know it's getting kind of confusing for some people. But this motion is specifically about Rachel Krause recusing herself to review the recusal of Judge Glanville. Okay. So this is what this motion is about. Kablutsky, you see that RK? That RK right there let you know that that's Rachel Krause right there. She did this today at 4:02 p.m. Eastern time. State of Georgia versus everybody. Order denying motion to recuse Judge Krause from hearing recusal motion. This case was randomly assigned to this court to consider certain motions to recuse Judge Glanville from further proceedings in the case on July 8th, 2024. Defendant Jeffrey Williams filed a supplement to motion to recuse Judge Glanville. Though titled supplement, a portion of the filing seeks to recuse this court from hearing the recusal motions. Remember, we just read it. Because Judge Glanville, remember now, for all of you that just coming in, Judge Glanville gave Judge Krause this year in April $2,000 for the campaign, for her campaign. For her campaign. He donated $2,000 to her. Now, in the actual supplement, there was a misspoke. He misspoke in one area because he was saying and insinuating that it was reciprocated, this particular donation of $500, but it's not true. But the $2,000 is true. He has given Rachel Krause $2,000 for campaign now this year. Now watch this. Now, it's been said that it's not uncommon for that to happen. However, the amount is commonly 500 some odd dollars here and there. Not a small portion, maybe a high portion, like 800, $2,000. That means that y'all like this. So the fact that this supplement to motion, the recusal of Judge Glanville, has a portion of her in there to recuse herself is because, again, Weinstein has an order to recuse everybody. Every last person in Fulton County that's a judge. Your motion to be recused is by Weinstein, right? So it's a lot of stuff going on and all that kind of stuff, but this is the motion today. All right. And so it says here, this court therefore must consider the portion of the supplement, quote unquote, seeking this court's recusal before proceeding further. So they're reviewing this actual recusal as they should. So Rachel Krause is doing what she's supposed to do at this point. When a judge assigned to a case is presented with a recusal motion and an accompanying affidavit, the judge shall temporarily cease to act upon the merits of the matter and determine immediately whether the motion is timely, whether the affidavit is legally sufficient, whether the affidavit sets forth facts that, if proved, would warrant the assigned judge's recusal from the case. If all three criteria are met, another judge shall be assigned to hear the motion to recuse. On July 9th, this is the footnote right here. On July 9th, 2024, defendant Williams filed an amended supplement to remove an assertion in footnote 2 of the original supplement. Facts. All right, they're stating the case here. Defendant Williams' motion in footnote 2 and later a lengthy paragraph 52 asserts two bases for recusal of this court. Defendant Williams asserts that recusal is merited because of a $2,000 donation made by Judge Glanville to this court's recent re-election campaign. Defendant Williams also asserts that recusal is required because it is inappropriate for any judge to preside in any action where one of the parties holds a judicial office in any other court which sits in the same circuit. Defendant Williams' supplement seeking to recuse this court is supported by an affidavit, albeit only one footnote in paragraph 63 as to this court. And it was filed within 5 days of this court being assigned to handle the case. Therefore, the first two criteria are satisfied, and the only consideration for the court is whether Judge Glanville's campaign donation to this court's re-election campaign warrants recusal. Are you kidding me? This is a dirty game out here, y'all. This is a dirty game out here, man. Oh my goodness. This is a dirty game out here, yo. You don't find no... The conflict is remarkable. Come on, man. Oh boy. The Georgia Supreme Court has held that the mere fact a campaign contribution to a judge, even from a party to the case, does not warrant recusal where the contribution was not exceptionally large. Oh my good, because it isn't. Remember, I said the limit, the fact that it's $2,000 is considered an exceptionally large amount of money. Wow. She cited a case. All right. See here. The Code of Judicial Conduct reiterates this point, noting that when a campaign contribution is less than the maximum allowable contribution permitted by law, and by the way, they just rose it up an extra $800 in Georgia. It was $7,600. Now it's $8,400. That's the max you can donate. An affidavit seeking recusal must allege additional facts demonstrating the need for recusal. And you can cite this case here. In summary, Rule 211A.4 provides that if contributions made to a judicial candidate or to that candidate's campaign committee are permitted by the law and do not exceed the maximum allowable contribution, then there is no mandatory requirement that the judge recuse. And because under Georgia law, the asserted campaign contribution would not warrant recusal. And defendant Kendrick has not alleged any additional facts demonstrating the need for recusal. He has not met the third criteria for recusal. Who that sound like? Don't that sound like... Didn't that sound like Glanville before the Supreme Court got involved? Oh, man. Defendant Williams' additional assertion of Judicial Qualification Commission opinion 220 in support of his motion is unavailing for two important reasons. First, Judge Glanville is neither a party nor counsel in this criminal prosecution, nor is this a mandamus action. And defendant Williams cannot make it so by filing a recusal motion. Can't make it so. So opinions 220's conclusion that a judge should not preside in an action where one of the parties holds a judicial office in the same circuit does not apply to this circumstance. Listen, it may apply, but it don't apply to this right here. The girl Richard Krause, man. Second, and perhaps most importantly, defendant Williams' motion ignores the clear directive of Uniform Superior Court Rule 25.4. That rule directs that in a multi-judge circuit, like the Atlanta Judicial Circuit, a recusal motion shall be assigned for a hearing to another judge, and the selection shall be made by use of the circuit's existing random impartial case assignment method. This court does not relish the task to which it has been assigned. In other words, I don't want to do my friend like this. I don't take pleasure in possibly having my $2,000 friend. I'm not trying to have this. I don't want to. But it is as much the duty of a judge not to grant the motion to recuse when the motion is legally insufficient as it is to recuse when the motion is merit. I can't pronounce that. However, in other words, I cannot pronounce it, but I can understand merit is in there. So they're saying that it's still, the fact that I'm doing this, have the right to do this. I have the merit to do this. I am not biased. I am not compromised. I am not. Yeah. Okay. Sure. Okay. For the foregoing reasons, the portion of defendant Williams supplement and amended supplement seeking to recuse this court is hereby denied. It is so ordered this 9th day. The Honorable Rachel Krause. She has denied her portion to recuse herself, and that she has denied it. So she is still going to recuse or going to review the recusal of your boy, one used to be Honorable Chief Judge Glanville. Yo, we got through this. We got through this stream, man. This is my longest stream ever done. It's longer than the person. What do you all think about this? Let me go to the comments real quick. I kind of missed some stuff here. I apologize, everyone. I was trying to get through all of this. Dove Cuz says, but if anybody would have paid attention, they would know he is being targeted. Yeah, because Fonnie Willis said on national TV that she is going to make him do, what's the TAM mean? No matter what time. Okay, I got you. She's going to make him do time no matter what. You know what? That's what Brian Steele, when we looked at the video, that's what Brian Steele was talking about. Like, he's just been targeted, man. You know what I'm saying? Abundance says, I feel Steele has a lot of information, but still has some questions that he wants answered. Absolutely. I think I agree. DPJ, the incompetence of the judge and prosecution is actually helping Brian Steele get a mistrial. I have to agree with that. They didn't want the cameras to see Woody being walked out in chains, but the cameraman captured it anyway. Exactly. That's what we talked about when I dropped that. When I dropped the last video where you saw Woody confirm what happened between Friday and that Monday, when he talked about he went to Reich first and then they put him in Cobb. Like they had him isolated, no water. Okay. Talking about he was gonna unalive himself. I mean, unbelievable, man. Unbelievable. D. Pill said that's exactly what he told the judge. Love lied about everything. Exactly. This is something that we need to really understand too. The way DA Love embellished the, so this is for your best interest of your client or for the best interest of Mr. Steele's client. Like, all of that was an embellishment, yo, to coerce Lil Woody to testify. Confused conservative. Miss, I like that name. That's clever. Miss Love has a light of shame on her head. You damn right. You damn right about that. And look here. Remember now, I did a video not too long ago about Miss Love's medical emergency for the family. And so this is, it gives more time for her to be able to implement a response that is so ordered by Judge Rachel Krause. However, I was asking people do they think that Miss Love was being honest? Was she being honest about that, or was she actually stalling for time? You know what I'm saying? So right here, I got a question here. 56 votes. All right. I appreciate everybody coming in. Appreciate you. Do you think the state has a legitimate RICO case against Young Thug? I asked that. 84% of the people said no. And 16% of you all said yeah. Wow, that's amazing. That is amazing. That's amazing. A lot of people don't believe the state, A lot of people don't believe the state at all. They're trying their best. They're trying their best to wiggle out of this. Absolutely. Witness Glanville. Can you imagine that? Can you imagine the very courtroom that you have ruled against other people? The very courtroom that had other defendants in chains standing before you with their counsel. You're going to have to now sit in that courtroom on the witness stand, bro. All because of an ex parte meeting that you was not supposed to have, man. Crazy, man. It's crazy work out here. Crazy work out here. Love and Hilton, both of you are in trouble. Absolutely. They're in trouble. They know it. They know it. I didn't think she was, but I didn't want to sound insensitive. I'm not sure what you was talking about right there, Abundance. I apologize. I was going in a little bit. You didn't think she was what in particular? Talking about Miss Love. So what are we learning today, man? So basically tonight, I mean, I appreciate everybody for just sticking with your boy today. I really do. I had to talk about this. We over 500 subs. I had to do this. I was going to do a video, but I'm like, nah, I got to talk to the folk. I got to be in it. DPJ said, I think the court reporter, Christina Weaver, worked with the judge to remove key things out of the transcript. You damn right. And then she put her name on it. Again, it wasn't a redacted transcript. But it's definitely it's missing things. It's omitted. Okay. It's definitely been proofread for sure. Okay. I mean, from June 10th all the way to July 1st, and the way the case is going, would you believe that the transcript is going to be full? You're supposed to get the transcript that day, like right after court, without any type of time. Then he said, but watch this though. Remember, you got to go back. We got to go back a little bit. You got to remember when he did decide that he was going to release the transcript. He said that he was going to remove some portions, or he was going to redact some of the things. Then he turned around on July 1st and said, okay, we're going to give you the full transcript. Dirty dog, pituitary Glanville. Oh, okay. Being honest about the family. Okay, so you said I didn't think she was, but I didn't want to sound and said I got you. Yeah, we need that audio. We need that audio for sure. We definitely need that audio. Yeah, the family emergency thing, the fact that it happened so like that day and that abrupt and all that. I mean, again, when you have a track record of not being honest, then every move you make is going to look dishonest to people, even if it is an honest move. Even if you're finally telling the truth this time, it is going to be deemed as dishonest only because of the fact that you got a track record of being dishonest, man. All right. D Pill, what do you think about how the jurors is thinking right now? I'm gonna be honest. I think the jurors know some stuff. I'm gonna be honest with you. And I think they have a hint of something. They are I know they're upset for sure. And I know if I'm a juror, I'm thinking to myself, like, man, what y'all got me into? I'm missing work. I'm like, what y'all got me in, man? Y'all got me in some a mess. You know what I'm saying? Like, why isn't if I'm a juror that let's say I don't know anything. Okay, why is it taking so long for this case for me to get back so I can do my thing? Now I'm thinking more on a suspicious level than a level of, oh, well, the court just handling business. I just, they're just taking their time with things. No. You got news, you got internet, you got social media, you got family, friends, other people that watch this stuff. You mean to tell me they don't know anything? Stop it. Stop it. There was a lady by the name of Infamous Sylvia, I believe. I think she's on YouTube as well. She goes to the courthouse all the time. And so a lot of people got mixed emotions about her too. I'm not familiar with her like that. But a lot of people got mixed emotions about her because they say she gossip and do all that kind of stuff. You know what I'm saying? So, but she was saying something about one of the jurors was a young lady and she had got dismissed because of, I forgot what reason she said, but she was removed and somebody had replaced her. So when they finally picked their people, I mean, it's mostly some women, mostly women in there, I think she said. Then there's other gentlemen as well. But the jurors is definitely, I know that they are watching TV. They like you said, they watching TV. Come on now, they got to be. Come on now. There's no way they don't know something. First of all, it's public record, all that kind of stuff. And the fact and the way that Fulton County handled business, you best believe they know something. They know something. Me to tell me they ain't got no cousin, no family friend, no nothing, no friend that's like, yo, you heard about the judge in that secret meeting? Black folks, man, we talk, man. We kick it now, Hey, yo. What up, though? Yo, what up, though? Hey, you heard about such over there, you know what I mean? DPJ, go take a look at Christina Weaver's Facebook. Several pics of her hugged up with the judge. Really? And the prosecution team, yeah, she worked with. Oh, well, yeah. I mean, it's not too uncommon that people have like tight knit relationships, but yo, that dude again. Once you look suspicious all the time, then you're gonna look suspicious every time. You feel me? For real, that's real talk. Says I have mixed emotions about her. I feel you. I 100% feel you. I 100% feel you. Yo, man. So look, I thank you all again so much for rocking with your boy today. This Thank you all so much once again for being a part of TayBiz TV, man. Hope you all enjoyed the show. Hope you all enjoyed everything that we reviewed today. And again, we took that time. We was reading the motion. For those of you that's watching this a little bit later, we was reading the motion, the supplement motion of Brian Steele. And then what we did was we took a look at an old clip of Brian Steele talking about and representing Young Thug in an interview of how he painted his client, and the fact that when you pick a lawyer, you want a lawyer that's going to paint this picture for you in a way that you can can't articulate, because that's what they're here for. They are here to do that. You know what I'm saying? They're here to represent you. And so they speak for you, and the way that Brian Steele was speaking for Young Thug was just like amazing. So we was looking at his demeanor, and we was contrasting his demeanor and comparing his demeanor then to the way it is now, not calling Judge Glanville honorable. He stopped calling him honorable in the motion. He called the man an actor. He said everything he's done is unethical. impartial. Man, he's talking about his judge. You know what I'm saying? So go ahead if you can to take a look back at this, and hopefully you will enjoy yourself. The world is talking. Absolutely. Say if you go to the barbershop to get a fade, you're gonna hear about the case. Exactly. You're gonna anywhere you go, you're gonna hear about this case, man. Abundance said, "Thank you everyone for being a part of the live." Yo, I appreciate it so much. I appreciate it so much. Yo, everybody enjoy your night, enjoy yourselves, enjoy your families. Always stay real, always stay true. And I'll holler at you in a minute. Enjoy this time with your people. Have a good night. I'm about to go to bed. I'm a little bit on sleepy mode right now. We was working tonight. All right. Peace. Much love.
I brought that with me. Case they get too easy. Baby, don't stress, don't sweat it. Put it all on my daddy. Know how I'm coming. And they know what we had. Run around through that left side, low end. All of mine need more wins. If you got beef, don't come out. My young hitter might go in. Uptown GN. Working all through my weekend. Hoping these don't show out. Cause all of my hitters too deep in. With the boy, I'm so ashamed. Ain't worried about long as my money and my green. Baby, I ain't got work tomorrow. Tell me what the business is. Ain't about no club hop. I'm trying to start some businesses. Shorty, you thought it was, they better know it's not that. Talking all that online, they knowing that it's not fake. Sliding through my hood, I make maneuvers like a Uber, baby. Got a 10-year plan, these can't tell what they doing lately. And I'm way too clean, I'm Listerine, I thought they been knew it. All in my lungs, I got my red cup full of that hint fluid. Young middle Mad Mac, I'm swinging that leg, I'm banging that do or die. And I ain't that legally before I get crucified. Living in my bloodline, this place in my family tree. How the they pressed, I did my best out of what they handed me. Straight out of that country, know my shawty dick as human air. And I need not mention no extensions, that's human hair. Boy,